Olmstead were confined in a state psychiatric facility. Thorpe takes disability integration, that struggle, to a new and more, well, not more important, but very important frontier. One of, in my opinion, one of the most important disability integration frontiers today, which is nursing homes. My role tonight is to tell you how the Olmstead case got started, which will include a little bit of my journey and the journey of the two plaintiffs, and then cover the very basic outline of the decision itself, unless I get called for time. By way of background, I worked for 10 years with legal services in Florida and North Carolina before I had any interest in disability rights. In fact, I'd never been inside a state hospital and didn't have any particular background in disability rights, but I had an opportunity, I had the occasion to be inside a state hospital in North Florida, and I was just shocked at the inhumanity of the place. And I had that sort of light bulb moment, and I decided the people in here probably have no idea what rights they have, and it would be a huge understatement to say that these individuals could use a little legal assistance. So when I say they didn't know what rights they had or were affected, I'm talking about really fundamental rights like freedom and autonomy. So as Bob Burko pointed out, what we were seeing in those years were people tied to their beds for hours, locked in seclusion rooms for days, forcefully medicated without consent, cut off from their families and friends. Most shocking to me was the utter disregard of human dignity, lack of privacy, and danger. So there were, of course, well-meaning staff. There still always are well-meaning staff, but there was a lot of cruelty and indifference. So when I moved to Georgia, I wanted Atlanta Legal Aid to serve people in state hospitals. I decided to go into the hospitals. I passed out my cards. I found a sympathetic social worker or two, and before long we were able to start a little project inside the hospitals. Now by the time Lois and Elaine, I'm going to try to do this. Okay, by the time Lois and Elaine became there's Lois. By the time Lois and Elaine, the plaintiffs in the Olmstead case, were Atlanta Legal Aid clients, our project had been going for 15 years. We didn't typically file federal cases. In fact, I would often just write letters, call, make phone calls. And if those didn't work, maybe some administrative advocacy, we would go to state court or probate court. Mostly we were challenging the kinds of practices that we've just been mentioning, which were rights of people to appropriate treatment inside the facility. In 1995, when Elaine and Lois came to legal aid, there were two factors which actually led us into federal court. One was, although both of them had experienced a lot of abuse in the hospital, the problem they presented to me was not about a violation of their rights in the facility. It was about the need to live in some decent, half-decent, at least safe, community-based place with services. And when I say community services, I'm talking about a range of things like peer support, vocational opportunities, educational opportunities, assistive technology, educational opportunities, and assistance with managing daily life. In other words, Lois and Elaine needed more than just a brief respite sort of in the community where they would stay for a week or 2 weeks or a month, and then they would hit the revolving door right back into the hospital. So the second reason we headed to federal court was also state law remedies were inadequate. Most state laws did require that before you could involuntarily commit somebody, it had to be, quote, the least restrictive environment. But state laws didn't provide or require or obligate the state to provide anything in that community-based environment. So we hope that a federal law, the ADA, would offer the solution we need. Now I'm going to tell you just briefly about Lois and Elaine. Lois and Elaine both were diagnosed with schizophrenia, developmental disability, and on top of that, as if that weren't enough diagnoses, they were people with, quote, behavior problems, unquote. It was clear to me, or to really pretty much anybody, that their, quote, behavior problems were the result of years and years and years of being institutionalized. Lois was in her early 30s. She'd been raised in public housing. Her mom was always terrified that if she wandered out, like especially when she became a teenager, she would get in trouble. And in fact, she was vulnerable and had some intellectual disabilities. So her mom got in the habit of calling the police, and the police got in the habit of trucking her off to a state hospital. Until that was sort of what happened to Lois when she went wandering. Next thing, she's in a state hospital, and she stayed longer and longer and longer each time. Shortly after the Olmstead case was filed, Lois was placed in a pretty decent community alternative with a nice, detailed community service plan. And Lois has never been back to a hospital. She is an accomplished artist. She exhibits her work all over the country, actually, right? And so that's Lois. Elaine was raised by in a middle-class family, and her mom was told when she was a child that she would be best served or treated or cared for in an institution. So Elaine spent 45 years, most of 45 years, in an institution before we filed our case, and then 8 years in freedom, so to speak, until she died in 2005. She'd been hospitalized 65 times before she got the services she needed. And once she was finally free of the fear of reinstitutionalization, her personality just totally blossomed. She was outgoing, sociable, friendly, and had a terrific sense of humor. During her 8 years of freedom, she developed a slideshow with a narrative about her journey from the mental hospital to independence. And with the help of an assistant, she went around and told her story. What I most remember about Elaine is she had this nurturing concern for Lois when they were together. Elaine was just always looking out for her. And also she wrote the best thank you letters to the lawyers. I already wrote it. Okay, now the case. It's Title II of the ADA that is the heart of the Olmstead decision. And it's the basic language of Title II is public entities shall not discriminate by reason of disability. And then we have the second important legal premise for the Olmstead decision is the integration regulation, which we've heard about, which requires public entities to serve people with disabilities in the most integrated setting appropriate to the needs of the individual. So the Olmstead plaintiffs were segregated in a state psychiatric institution. The case also applies to people in nursing homes because although they may be a private nursing home, they are utilizing or serving people through public programs. The most obvious one being Medicaid, but there are other public programs that serve individuals in nursing home settings. Okay, so the Supreme Court in a decision that we're talking about answered or responded to Lois and Elaine's claim by saying specifically, this case concerns the proper construction of the anti-discrimination provisions of Title II, and specifically whether that provision requires placement of persons with mental disabilities in community settings, which is where the affirmative obligation comes from and what makes a big difference since Olmstead. So that's how Justice Ginsburg articulated the question, and then she answered it by saying, we respond to that question with a, quote, qualified yes. And her yes was qualified by three, what's called often the three prongs of Olmstead. One, treatment professionals have to agree that the person can benefit from community services. The person is not opposed to community placement. And finally, the placement can be reasonably accommodated given the needs of all the other people in the disability service system. And another way to put that third prong is the state is not required to fundamentally alter its system if it has a plan of action that moves people along into the community at a reasonable pace. Okay, all of you law students and lawyers know that there's a lot of problems with that language, and it's very challenging to subsequent litigators, but I hope it's true for me to say that as the cases emerge over time, the integration principle is carrying the day. So the big step forward is that the state cannot justify segregation by showing that it provides treatment inside this institution. If the treatment can be provided in the community, then too bad, that's where the state is obligated to provide the services that the individual needs. And my favorite part of the decision is the language that the Supreme Court chose to use, which is, as Professor Bergdorf said, it's totally stating the obvious, but the obvious hadn't been stated yet, which is why segregation is discriminatory. So under Olmstead, to conclude, unnecessary segregation is discrimination. And I wanted to say one quick thing in conclusion. We had no idea we were going to the Supreme Court, okay? We didn't plan it, we didn't imagine it, we didn't anticipate it. And when the court granted cert to the state, we were thrilled, but we were also terrified. So that is sort of the point in time that an ad hoc coalition of amici and every civil rights advocate in the country came to our aid, thank God. And they helped convince the Supreme Court that Lois and Elaine deserved to live in a community like everybody else, and that if the community services weren't sufficient, the state ought to just get busy and do something about it. Back at Legal Aid, we realized that one case is not really what results in freedom from segregation. It's a long history of struggle, and the struggle continues. So those are my thoughts, and I'm going to move along to our wonderful next panelist, Joe Shapiro, but I have one secret to tell, which I got permission. We already heard his introduction, but I was an accomplice once in Atlanta when Joe came down to interview some of our clients, and I had promised him this guy, wonderful client of ours in the state hospital. When we got there, they wouldn't let him in. So we smuggled him out into the back seat of his car, and Joe interviewed him.